Elliott versus Durrani. And the third case is State versus Kidwell. State versus Kidwell has been submitted, so only the first two will be argued. And let's start this morning with Bachman versus Cincinnati General Hospital. Counsel, if everybody could introduce themselves and indicate their readiness to proceed. Mr. Winters, let's start with you.
Yeah, good morning. Morning, judges. Bob Winter on behalf of Gail Bachman et al., the appellants, and with me today is my co-counsel, James F. Moss.
And will you be arguing, Mr. Winter?
Yes, ma'am.
All right,
Yes,
thank
sir.
you. Counsel?
Oh, we're ready to
Jennifer
go.
Mitchell, on behalf of the Christ Hospital, Your Honors. I believe that Cincinnati Children's Hospital has dismissed from this appeal, given that it has resolved its claims. So I believe I'll be the only defendant arguing.
All right, thank you. Mr. Winter, you have 15 minutes, as you know. Would you like to reserve any of that time this morning?
No, Your Honor, I think we can deal with this case pretty quickly. The issue before us is whether the trial court erred in denying the appellant's motion to consolidate under Civil Rule 42A and dismissing the case with prejudice. And as counsel has said, the claims of my clients against Cincinnati Children's Hospital have settled. So consequently, there's nothing to consolidate, and this aspect of the appeal is moot. Estimation, unless somebody tells me otherwise. I looked over and over at my conclusory statement in both my briefs, and the remedy was consolidating the Children's Hospital case with the Christ Hospital case, and there's nothing to consolidate. So I think we're done with this aspect of the case. The only thing that we have left that I see is the trial court dismissed this appeal with prejudice. We respectfully contend that it should be dismissed without prejudice and let the underlying cases rise or fall on their own merits. I will say off the record that the Christ Hospital has been successful on these matters, and they don't need a res judicata argument in future cases that have yet to be decided by this court.
Well, Mr. Winter, can you help me out? I just have difficulty in understanding why this action was filed, given that the very plaintiffs who are parties to this case, as I understand it, were already parties in other either pending or dismissed actions. So, I mean, why did you file this case?
In the case, are you all still with me? I lost the.
Yeah.
Yes.
Oh, okay. Oh, there you are. Good. This was a case where the plaintiffs discovered that the surgeries had been performed at Christ Hospital as an employee of Children's, and we were going to assert a claim against both of these entities and then consolidate this case with whatever cases were existing. That there are some folks that whose cases have not been, or that were final. Some were in the process of being in some aspect of appeal, and those matters have been dismissed from this appeal, leaving only those folks that had claims against Christ and Children's. And since we no longer have Children's claims, we have claims against Christ. As to those folks whose cases are still unadjudicated.
So
Ms.
this,
Winter? Go ahead,
Yes.
Judge Bergeron.
well, at this point, is consolidation off the table for purposes of this appeal? The whole analysis on consolidation based on what you said a moment ago?
Yes, yes,
Okay.
because excuse me, Your Honor, there are no claims against Children's Hospital, so there's nothing to consolidate. All that remains are the claims of these appellants against Christ Hospital. Now, I will
And
also say,
don't those remain in other pending actions? Duplicative, aren't they?
right. Well, yes. I mean, they were duplicative in several ways, and thus we were going to consolidate them based on the Russo case.
So
Russo
I guess my question is, isn't the entire appeal moot? Because I agree with you. The first question I was going to ask you, if you didn't address it, is, isn't this moot because of the children's settlement? And once that's determined, I think that was your sole assignment of error, that it was error not to consolidate. And if they're pending cases and the claims are preserved, doesn't that moot the entire appeal?
except for one point. The trial court dismissed this case with prejudice, and that would enable Christ Hospital, at least as an esoteric matter, to state in the other cases that we now have a decision on the merits in this case. Consequently, we would ask that this court remand this case to dismiss without prejudice, and if it be without leave to renew, because there's nothing to renew, there's no consolidation. And that the cases of, for example, several of these appellants, their individual cases may proceed. It is moot.
If I were to ask Ms. Mitchell when it's her turn to argue, if she were willing to stipulate that the dismissal by the court of this case would have no impact, as you've suggested in the other cases, would that satisfy you? Because again, I'm not sure that that's raised as an assignment of error. Maybe it is.
That would say,
all right.
I believe I objected to the dismissal with prejudice. However, if Miss Mitchell is willing, I'm willing.
All right.
Well-
Because I guess the reason I asked that is until you just argued it, I'm not sure I focused on that point. Your argument, I want to make sure I understand, is not so much the dismissal, it's that it was with prejudice so that it might, under your scenario, affect the claims that are currently pending in a different case.
Well, I'll just practice a little belt and suspenders law, Judge Myers, and we want Price motions to dismiss in the other cases be decided on the merits, not because of some argument that the res judicata because of what happens in this matter.
Thank you.
And that's really all I have.
Any other questions from the panel? Mr. Winters, you will have about 7 minutes left if you'd like to use it when we get to that point.
Thank you.
All right, Ms. Mitchell?
Thank you, Your Honors. I believe that we would be willing to so stipulate. However, I don't think that it's necessary. And what I was looking for as the court was questioning Mr. Winter was the references in the trial court's order. But I believe that the trial court's order in this case, dismissing it, specifically stated that it would not impact any of those other pending lawsuits. So I don't know that that's an issue that even remains for this court's consideration, and I was trying to find the reference, but was unable to do so in the few minutes before my time started. But the court did say, in as much as these plaintiffs have or have had access to this court in other proceedings, and they cannot provide this court with any legal authority for or reason why this case should proceed. This duplicative action shall be dismissed. And then went on to say, while plaintiff's counsel made an effort to explain why this action was originally filed, he was unable to explain why it was not subsequently dismissed, why the defendants were required to seek this motion, and why the court was required to hear and decide the motion. And in fact, procedurally, what happened thereafter was that the trial court actually sanctioned the plaintiffs for filing this lawsuit and awarded the Christ Hospital its attorney's fees for having to defend it. So I was a little bit surprised by the fact that that Christ Hospital was even included in this appeal in the first instance, because these claims were completely duplicative of already pending claims, as argued in our briefs. So I don't know, given the limited argument by Mr. Winter, that I need to go into anything else argued in our briefs. But certainly we would not and have no intention of arguing in any of those other appeals that have yet to be decided, that the dismissal in this case somehow also impacts the merits being argued in those cases.
Would you
So
agree
with that,
that, would you agree that it was improper for the trial court to dismiss this case with prejudice?
I don't believe so, no, because of the nature of the filing as being frivolous in this case. I do think it was proper to dismiss it with prejudice because it shouldn't have been brought at all to begin with. The claims were already pending. In a number of instances, the claims had already been dismissed or were otherwise improperly filed because they had missed certain deadlines, statutes of limitations, and whatever have you. So what the court asked the plaintiffs at argument at the trial court, why did you bring Christ in this case? I think that they, to their benefit, were trying to bring claims against children's and get those claims consolidated into already pending lawsuits against Christ. I'm not sure why they didn't just seek to file in those lawsuits, but what they did was combine claims of 36 plaintiffs who already had pending lawsuits and replicated the arguments and the claims and the allegations. They were identical in all regards. So the court looked at this as a frivolous filing and entered sanctions and dismissed this case with prejudice, not on its merits, but rather on the fact that it should have never been filed in the first place. They didn't get into any of the claims because those claims already existed and were already being ruled upon separately.
And so did you say it's 15 plaintiffs, their cases had already been decided on the merits, and then there was 20 that the cases were pending? Is that right, roughly?
I think by now all of the cases have been decided on the merits. At the time of the filing, I believe there were 3 or 4 that had already been dismissed by the trial courts on the merits. And then there were several others that shouldn't have been brought because of the two dismissal rule or other rules that would have precluded them from being filed. The remainder were all pending cases that were identical. So
at this point, what you're saying is at this point, all of the plaintiffs have had their cases resolved on the merits. So Mr. Winter's concern about somehow using res judicata from this disposition wouldn't really work even if you wanted to do that.
Right. I looked through the list of those who have cases, and I believe every single one of them has been decided on the merits at this point and is proceeding in some fashion before your court on appeal. So with that, I really don't have anything else other than to say that we don't believe that we believe that the court should affirm the trial court and rule in favor of the Christ Hospital. Thank you.
Thank you. Any other questions for Ms. Mitchell? Mr. Winter, you have 7 minutes if you'd like to use any or all of that time.
Just at TD 101, page 4, the trial court granted Christ Hospital's motion for judgment on the pleadings and dismissed all plaintiffs' claims against all defendants shall be dismissed with prejudice. And then the trial court said this dismissal shall have no effect on the merits of any of the other actions brought in the name of these same plaintiffs. So, I agree with Ms. Mitchell that the trial court attempted to preserve the merits of plaintiffs' claims and Christ Hospital's defenses, but again, being a belt suspenders type of practitioner, a dismissal without prejudice in this case seems appropriate. I've looked over, and as an aside, I've looked over the list in my notice of appeal of my clients, and I think most of them have cases that are either finished one way or the other or pending before this court. And lastly, the Christ Hospital was awarded costs and attorney's fees, and those issues are pending before this court to be heard on a later date in case number C-19-00514. So we'll be back with your honors on the frivolousness and costs and attorney's fees at another date.
Well, you just raised a question in my mind then, Mr. Winter. Do we have a final appealable order in this case then, if the attorney fees were still pending?
The trial court said we had a final appealable order under which it was document number 105. And then he entered a final appealable on the attorney's fee.
Well, as you know,
Yes.
the case law is until the attorney fees issues are decided. Well, I don't want to get into this, but I don't want to speak out of turn because I haven't looked at it, but that just sparked that question in my mind. Let's put it that way.
No, that's mine
Was there
too.
54B language in the order that you've appealed from, the consolidation and dismissal order? Well, let me ask a better question or a different question. Did the motion for attorney fees come after the ruling on this motion?
Yes, ma'am.
All right, it was like a Rule 11 or a statutory
Right.
motion for
Yeah.
fees? All right.
Yeah. Yeah.
That
Mr.
probably answers my question.
Right.
Mr. Winter, I guess my question is like, is this entire appeal moot? Because if the only concern is using the potential preclusive effect of this case against the other cases to prevent their resolution on the merits, and if they've all been resolved on the merits, I mean, what do we have here to decide?
I think that's been my position all along, Judge Bergeron. Yes, sir, it's moot.
Okay.
But for the issue that you've just stated, it's moot.
Okay.
All right. That's probably a good place to end then, Mr. Winter, unless you want to add anything.
No, I've nothing more to say, Your Honor. Thank you for your time.
All right. Thank you all for your arguments this morning. We will give you a timely written decision in this case. I will be leaving and Judge Marilyn Zayas will be hearing the next case, and she will be the presiding judge for the next case. So thank you all very much.
Thank you, Your Honors.
Thank you, Your Honor.
Good morning.
Morning, Your Honor.
Is all counsel here with regard to Elliott v. Durrani?
Yes. Yes.
Okay, thank you. All right, so the next case we have is Elliott v. Durrani. If counsel can please identify yourself and state your readiness to proceed.
Good morning, Your Honor. Bob Winter on behalf of Ms. Richard Elliott. I'm prepared to proceed. With me was my co-counsel, James Moss. I will be doing the arguing.
Okay, thank you.
Jim Brockman on behalf of Dr. Durrani and Cast.
Mike Foley on behalf of Good Samaritan Hospital and TriHealth Inc.
All right, thank you. Would you like to reserve time?
2 minutes, Your Honor.
Okay, thank you. Just start whenever you're ready.
Thank you, Your Honor. Good morning, judges, gentlemen. The key facts in this case, in this Durrani case, are that Mr. Elliott underwent surgery by Dr. Durrani and Cast Good Sam on Good Samaritan, at March 1st, 2010. In December of 2013, Dr. Durrani fled, never to return. On March 12, 2014, Dr. Durrani had his medical license permanently revoked. On April 23rd, 2014, the Office of the Ohio Secretary of State administratively terminated Cast. The first action was brought against Dr. Durrani and Cast and Good Samaritan on June 12th, 2014. It was dismissed under Rule 41A and refiled in this case on August 19, 2015. The judge below dismissed the case because all claims asserted by Mr. Elliott were deemed medical claims. We would refer to the second matter presented for appeal, and that is the 2305-15A matter. We claim that when Dr. Durrani departed Ohio, never to return, he left the state, and consequently all limitations under 2305-113 were told.
Well, would it only be limitations with respect to Dr. Durrani and not to any of the employers?
It doesn't apply to Good Samaritan. We're not claiming any vicarious liability on its behalf. It would apply to Cast, because
And why?
Dr. Durrani is Cast. Wherever Dr. Durrani is, that's where Cast is. It was administratively dissolved before this lawsuit commenced. And under Tausch 187 Ohio App 3rd 173, paragraph 36, it says when a statute of limitations applicable to a physician is told pursuant to Freisinger, is what we have here, a related claim against the hospital on a theory of vicarious liability arising out of the physician's negligence is likewise told. And that's how the statute of repose is told against Cast under Tausch. That's our authority for that.
Well, can you go into a little bit looking at the language of the statute? I mean, obviously what the other side is arguing is it uses language about accrual, which we normally interpret as applying to the statute of limitations rather than the statute of repose. I know there's the Judge Delat decision that is in favor of you on this issue, but can you talk a little bit about what we should do with the use of language of accrual in 2305-15A?
This case had accrued at the time of the surgery. We've talked about that in Wilson versus Sand. It's the date of the surgery. And that occurred in March of 2010. And consequently, the 2305-15A applies when Dr. Durrani fled in late 2013. The case had accrued, and consequently the tolling of provision expressly applied to 113.
So you're basically saying that the term accrue in 2305.15 is intended to be more of a definitional term,
Yes,
used as the definitional term of accrue.
yep, yes,
So on the statute of repose, accrue would be with the last surgery, statute of limitations would be different.
correct, correct. That'd be an issue that we all know about under Freisinger and its cases. But I think Landrum is directly on point and not controlling, obviously. That's, I'm sorry.
I have no idea who's speaking.
Not me.
Yeah, no one that's in this is speaking.
Okay. All right. I just referred to the Garber versus Menendez 888 Fed Third 838 case, where it said that 15A applies to a statute of limitations matter, and there's no differentiation between a 113A statute of limitations and a 13C statute of repose matter. I refer
Wasn't that case clearly dealing with the statute of limitations?
Yes,
If you read it, right?
Yes. agree, but
And it didn't really deal with this issue though, that we have in front of us right now. I mean, it didn't delineate the statute of limitations section, but clearly the entire case was dealing with that. And it was, so how do we rely on that case? Precedent, or not precedent, persuasive authority.
It's persuasive authority, and 15A applies to any limitations discussed within 235.113, whether it be A, statute of limitations, or B, the judicially denominated statute of repose. The General Assembly discussed, courts and you and I discuss it as a statute of repose in subpart C, but the General Assembly uses the word limitation throughout 113. So I respectfully submit that while Your Honor is correct, Garber did not apply to statute of repose. It's equally applicable, and Judge DeLotte agreed with us on that point.
So the language in 2305.15A that you are pointing to that includes the it includes the statute of repose is just the fact that the statute of repose is in between these sections that are delineated in the statute. Is that why you're saying the statute of repose is included in the tolling?
Well, statute of repose is a 113 subpart C, not A. We would agree with that. And 113 lies between 2305.111 and 2305.112, under my understanding of the codification of the rules. Consequently, I'm able to make this argument. Did I satisfy your question?
I mean, I'm assuming that's it, because, before it delineates the sections, it talks about the period of limitation. And most of those sections deal with statutes of limitation. And so I guess you're just saying because the statute of repose happens to lie within those sections, it's included in this tolling statute.
Sure. And I think it's footnote 1, Judge DeLotte so found. On the same page as you. And, the statute of repose did not exclude the tolling provisions at 15A. In fact, 15A included it. So we're not left with a coverage issue under 15A as it applies to 113, whether it be at A or C. I'd like to move on to our claims of negligent credentialing against Good Samaritan. This doesn't apply to Ronnie Orcast. the trial court dismissed negligent credentialing as a medical claim, and this district has uniformly held that negligent credentialing is a medical claim in the McNeil, Christinger, Young, and recently in the Jonas cases. But Mr. Elliott respectfully requests that the court reconsider this because we contend that negligent credentialing is not a medical claim. Negligent credentialing does not arise out of the medical diagnosis, care, or treatment of a person. And that was held initially in Browning versus Burt. It was originally at one point stated by this court in Butler versus Jewish Hospital, and reaffirmed on other matters in Schelling versus Humphrey.
Well, Mr. Winter, we've made that decision pretty consistently across several opinions, and I assume you all have tried to get that up to the Supreme Court, and has Supreme Court accepted that issue for review?
Well, we have the one time we this court did not certify a conflict with the other courts of appeal, and it's currently under in-bank review on your decisions in McNeil, Christinger, Young, and Jonas, versus the Butler versus Jewish Hospital. That's the procedural posture. We've had one time that the Supreme Court has not taken this case, and that was, I believe it was Bradley Arnold versus Durrani. And once we get through these cases, we'll have 3 or 4. Jonas will be one of them, Andrew Carr. And I forgot the third one, Judge Bergeron, but there'll be 3 that we'll be filing for.
Okay.
Yes, you're right. You've decided them against us. You've held that negligent credentialing is a medical claim. One point I would just like to
Attorney
make.
Winter, just want to alert you, you have 1 minute if you still would like to reserve your 2.
Okay, I'd just like to make one point that maybe I haven't done very well on in the past, is that before a court can consider the phrase that Good Samaritan relied upon in the hiring, training, supervision, or termination of caregivers under the 3B2, a negligent credentialing claim must first arise from medical diagnosis, care, or treatment of any person. That phrase was construed under D3B in Browning and found not to be a medical claim, but rather an independent negligent credentialing claim. And I think I saved my time.
Thank you. Counsel, you can proceed whenever you're ready.
Your Honor, this is Mike Foley on behalf of Good Samaritan Hospital and TriHealth, Inc. I'm going to defer most of the arguments to Durrani's counsel, since I believe our issues have been resolved by this court on at least 3 or 4 occasions. The only thing I would add is the McNeil decision was declined by the Supreme Court. The Supreme Court did not take jurisdiction over the Cameron McNeil case, which was the same or similar issues as this case is before this court. As counsel for the appellant has stated already, the tolling issues don't apply to Good Samaritan Hospital or TriHealth, Inc. It should be noted for the record that Dr. Durrani was not an employee of Good Samaritan Hospital or TriHealth. At the time, he only had privileges at the hospital to perform surgeries for a brief period of time, but he was not an employee. So unless the court has any other questions for Good Samaritan Hospital, I would defer to Mr. Brockman for the remainder of the time allotted.
All right. It doesn't appear as if there are any other questions.
Good morning, Your Honors. Jim Brockman on behalf of Dr. Durrani and Cast. Since this case was briefed and February of 2019, as best as I could count it, there were 9 decisions by this court on the various Durrani issues that keep coming up before this court. I would submit to your honors that a number of the issues raised in plaintiff's appellate brief have already been decided by this court in other Durrani cases, and I don't think we need to rehash them at length. The other case that has already been addressed and has not really been talked about much this morning is what I call the first filing doesn't count argument. That is one of plaintiff's assignments of error. Your honors this court already decided that in Sand v. Wilson, that in fact, the first filing does count for purposes of the statute of repose, and you can go back and use the first filing even if it was voluntarily dismissed and then later refiled outside the statute of repose. But the Sand and Wilson case that was decided by this court is currently awaiting decisions from the Supreme Court of Ohio. I forget the exact date the arguments took place. I didn't argue it on behalf of Durrani and Cast, but I did watch it, and it was just about a month ago or so, if memory serves me. So one would assume that we'll have a decision by the end of the year, but you're never for sure. But Sand versus Wilson is not the determinative issue in this case, because even plaintiff's first filing in this case, if the absent defendant statute doesn't apply, was filed more than 4 years after the complained of act, and that's the surgery. So
Which leads us to the argument of the tolling. I'm sorry, which leads us to the argument of the tolling statute.
Correct. The tolling statute simply states that when a cause of action accrues against a person, the period of limitations does not begin to run if one absconds, conceals oneself, or is absent from the state until they return. Basically, the clock stops if someone's gone. Now, the other part about the statute that I think is important for the court's determination is there is no real evaluative judgment about why the person is gone, absent from the state, concealed, or absconding. It's just those things occur and the clock is told for limitations and accrual. As you set forth by Your Honor, Judge Bergeron, the statute that we're talking about, the absent defendant statute, uses the terms accrual and limitations.
Well, so it does. I think part of what I struggle with, though, is the tail end of the second sentence, because there it says the time period of the person's absence shall not be computed as any part of a period within which the action must be brought. So that seems to me to take it out of the realm of just a limitations period.
But I think when you look at the statute in its entirety and the purposes of a statute of repose, as we call it, as set forth not just by the Ohio Supreme Court, but also by the Supreme Court of the United States, it is supposed to put a final deadline upon when somebody can bring a cause of action. And as the Supreme Court of Ohio has held in Antune, it can terminate the cause of action even before it actually accrues. As we put forth in our brief, and as your honors know from some of your other opinions, and we've talked about these in the other Durrani cases, the statute of limitations, especially when it's got the discovery rule attached to it, for the beginning of the period of limitations, is plaintiff oriented. It's to protect the person that didn't perhaps know. But the statute of repose is defense oriented. It gives a final termination date upon which no cause of action shall go forward.
But if we use that logic, then the saving statute would not apply to the statute of repose.
Agreed. And that is why, well, I think we'll hear eventually from the Supreme Court of Ohio on that issue. Since that was argued just about a month ago or so. So we'll eventually figure out what that is, and that might give us a precursor.
So what I'm saying is, if that's the central kind of like, value or theme in this, then it should apply equally. And so the fact that it didn't apply with regard to the saving statute, doesn't that make it less persuasive to apply to the tolling statute?
Less persuasive, but not determinative, because the statute of repose is not the same as the saving statute. It serves a totally different purpose. It is to put a final deadline on when a cause of action can be brought by someone. Think about.
And so I hear you that the statute of repose is defense oriented, and I agree with that. But this involves a situation where the person is absconding or concealing himself. So all of the policy arguments that would normally militate in favor of adherence to the statute of repose seem to go out the window if the person is avoiding being held accountable for this.
Your Honor, I think the issue with what you raise is an issue, but if you look at the statute, the statute does not make a value judgment about why someone is gone. The statute doesn't differentiate between somebody going away because they retired, because they live in a different state, or because, as alleged in this case, they fled to Pakistan.
Well, I think abscond has some sort of connotation to it, which is a little different than I have retired and moved.
It does, Your Honor, but the statute talks about all three. And if this court decides that this tolling statute trumps, so to speak, the statute of repose, the policy implications don't just implicate what is alleged to have happened in this case with Dr. Durrani. Any particular doctor.
Well, I think this has to be also read in light of filing requirements and service requirements, right? So if somebody were to move and retire, it seems as if they would be, they could be found for the purposes of service. While if someone is concealing themselves, then it's going to thwart the ability to serve that person. And so I don't think that this could be read outside of the requirements in procuring service. And now this is going to trump people's, it's like, oh, well, they moved, so I didn't have to look for them. I didn't have to make my best effort to find that person.
But there are provisions within the civil rules of getting service on people that you can do it by publication even to try and get service on them at their last known address. There's
right, but publication, but you still have to make every reasonable effort to find that person. You still have that requirement before you can even get to publication.
And if, according to the allegations in the complaint, they have found him. They claim that he's in Pakistan. They claim not just that he's in Pakistan, but at Lahore. And they claim even what hospital he's at. They know where he is. And there's a treaty about service on people in foreign countries that could be done. That's why those extra things are in the rules about service, so somebody can be served. He's not, and I agree with Your Honor, when the term absconds is there or conceals, it does have a negative connotation. But this statute also says absent from the state. This would apply if this tolling statute defeats the 4-year limitation on the statute of repose. You have you expose doctors who live in northern Kentucky but practice at Children's Hospital to interminable liability. because the statute of repose never runs against them. They live over in Northern Kentucky and drive to Children's Hospital. You would impose an interminable limit of liability, potential liability, on a doctor who comes to Cincinnati for training, an intern, a resident, a fellow, or a doctor who comes here because that doctor is the doctor that can perform a certain type of surgery, and he gets privileges to perform a certain type of surgery at one of our local hospitals and goes back to whatever state he or she is from. Then you end up in a situation where that doctor goes back to his or her home state, and forever they are potentially facing liability. Because if this court rules that the tolling statute defeats the 4-year limitation, that person is exposed forever unless they come back and move to Cincinnati or the state of Ohio. That's the reason that if you look at the language that's in the statutes that talk about the statute of repose, for instance, Antoon, Ruther, and the Supreme Court of the United States opinions, it's an absolute bar. And in our statute of repose, there's only limited exceptions. In this,
So what about the provision in 2305-15A that incorporates the range of statutes that encompasses the repose period? Because, I mean, all of what you're saying makes sense, but the legislature effectively put that provision in here, and what are we supposed to do with that?
well, what I propose, the way to rationally put these two statutes together so they coexist is use the language that is in 2305-15A, where it talks about accrual, twice limitations, and agreed, as you said, Judge Bergeron, it's got this A period, and say that's the statute of repose. If we don't make a decision, strike that. If you don't make a decision that the statute of repose is what it is, says what it means, and is clear and unambiguous on its face, as the Supreme Court of Ohio has already stated, we end up in a situation where I've tried to say before, you've opened all sorts of medical professionals in the state of Ohio to potential liability forever. They come, I mean, think of, I'm kind of being a little bit local when I talk about Cincinnati and Northern Kentucky. You know, we border a couple other states too. That there's people all the way up in Toledo, the doctors live in Michigan.
Counsel, I just want to alert you that you have 1 minute left.
Oh, okay. Well, let me then just briefly point out that, again, a number of the issues that have been raised, and I don't have time to go through all of them, in Mr. Winter's well-written, well-reasoned, and well-researched, but incorrect brief. He said a number of those that have been raised, this court has already addressed. I've got them here if you need them, but I'm sure you all can figure it out. One of them is what
We're aware of those.
Yeah, I figured you were, so that's why I didn't stay on them. But in any event, just to close real quickly, the statute of repose has to have a final end to it. The statute, the tolling statute, talks in terms of accrual and limitations and applies to the statute of limitations, not the statute of repose, and this court should so hold. Thank you.
Thank you.
Am I on the clock?
Attorney Winter, yes, the floor is
Thank-
yours.
Thank you. I just wanted to make a point. The McNeil case is correct, not Bradley Arnold. And those two ran in my mind in case preparation. So if I can change that point to Cameron McNeil, not Bradley Arnold. One point that I think is significant is the concession that Dr. Durrani never was an employee of Good Samaritan. And consequently, I mean, he was a private contractor, and Good Samaritan did not hire, train, supervise, retain, or terminate Dr. Durrani for purposes of 2305-113E CB2, or maybe it's B2. He's not a caregiver, he's a physician, and I'll move on. Mr. Brockman indicated that the sword of Damocles will hang over the head of Dr. Durrani until he returns, and that's right. That's what the General Assembly intended here. He states that the statute of repose has to have a final end. Yeah, when he returns and 4 years runs. I agree.
Well, so I think your argument makes sense with respect to someone like Dr. Durrani, who has fled the country. But his point about the doctor who retires to Northern Kentucky or retires to Florida and are not actively seeking to evade service, like the policy justifications cut the other way, but we've got a statute that has all three in terms of you're out of the state, you're absconding or concealing. We have to make sense of those. So I'm just struggling with how that cuts in this when we have to take the statute as a whole.
There's a case out there where a doctor retired to Florida, and that issue's been decided already, if I recall. And Judge Bergeron, I just can't think of the name of that case, but that already has been before a court and has been decided. No, I don't believe it's this court, but if I recall, it didn't apply. I mean, if you'd like a brief letter on that particular case, I'd be glad to follow up. I'm sure Mr. Brockman would too.
But I think we can find it.
Okay, it's in the, as you've heard before, it's in the brief. Last point I'd like to make, if the 15A applies to the statute of repose, if a surgeon stays away, whether under good or bad pretenses, long enough to cause the statute of repose to expire, then he defeats the statute of limitations tolling, and 15A would have no effect. It would allow it to run. So 15A must apply to the statute of repose. And Judge DeLotte so found in Landrum. Unless you have any questions, that's all I have.
Thank you, Attorney Winter. And thank you both for your arguments this morning. We will take matter into submission, issue timely decision, and have a wonderful afternoon and keep safe.
Thank you.
Thank you. Honor.
Good
Have a good day.